In this video, we're going to have a look at appeals. This will mostly be in cases involving asylum claims or human rights claims, because the right to appeal in other kinds of immigration cases has been really restricted. You can have a look for more information about which kinds of decisions, which kind of cases get the right to appeal in the Right to Remain Toolkit, in the section After Refusal, and also Appeals First Tier Tribunal. This is going to be quite an informal look at mostly at the appeal hearing itself. If you want more information about appeals, about submitting appeals, do have a look at all the information we've got in the toolkit, and also check out the great video from Consonant, formerly known as Asylum Aid, on the appeal hearing. They've got a great animation that we link to. It's embedded in the toolkit page on appeals. An appeal is your chance to argue that the Home Office got it wrong when they refused your asylum, immigration or human rights application. You will argue this in front of a judge who is independent from the Home Office at a kind of court called the First Tier Tribunal. Let's have a look at where appeals come in the legal process. If we're talking about asylum claims, for example, let's have a look at this diagram. You've entered the UK, you've claimed asylum, you've had your screening interview, the short interview where quite basic information is taken. Maybe some weeks, some months after that, you've had your main substantive asylum interview. And then maybe some weeks or again some months after that, you'll have received a decision from the Home Office. In the case of asylum cases, most people will receive a negative decision, a refusal from the Home Office. As you can see from this other diagram, an appeal, if you have the right to appeal, is potentially just the first step of what can be quite a long and complicated process. So it's not necessarily the end of the road if you don't win your appeal, but appeals are really, really important, and it's really important to prepare for them as much as you can. If you've received a refusal from the Home Office, you have just 14 calendar days to submit an application to appeal. There's no permission stage for this level of appeal. You don't need to ask the court for permission to go ahead. If you have the right to appeal, then you go ahead and put your application in. If you've got a lawyer, they'll prepare and submit the appeal form for you, and will also arrange for somebody to represent you at court. It's not usually the same person. If you don't have a lawyer, you can submit the application yourself, and you'll find more information about this on the toolkit page about appeals. After you've submitted your application, you'll receive a notice of hearing, and this tells you when and where your appeal hearing will be. This might not be for many months, maybe even over a year after you've submitted your application, because there's a long backlog of cases to be heard at the tribunal. Your appeal hearing will be at the First Tier Tribunal, which is a kind of court. It doesn't look anything like the big courts you see on TV or film, for example, but really important decisions are still made there. At the tribunal, there's different kinds of cases that are heard, so there might be hearings happening for employment law cases, or family law, or social security welfare benefits, but your hearing is part of the Immigration and Asylum Chamber of the First Tier Tribunal. There's tribunals across the UK. There's one in Belfast, in Glasgow, in Newport, in London, in Manchester, in Bradford, for example. You should have your hearing either near to where you are now or near to where you've been at some point during your application. In certain circumstances, lawyers can request a change of location for the hearing, but it doesn't happen very often. It won't be completely random. So if you have been living in Birmingham for the whole time, or Birmingham and Manchester for the whole time of your application, you're not going to have your hearing suddenly allocated to Belfast in Northern Ireland. It's really important that you know where the hearing is and how to get there. The tribunals can be really far out of the city, so Newport is an example of that, or they can be right in the middle of busy shopping streets like Manchester Immigration Tribunal. If you're on asylum support, you can get your travel ticket provided for you, but you do need to ask for this to happen. It's not automatic. However you're getting there, make sure you know how long it will take and how to get there and how you'll get back, because you don't want to be worrying about these things on the day. On the day of the hearing, your appeal will be listed to start at 10 a.m, but everyone whose appeal hearing is that day will also have their appeal listed at 10 a.m. Now, there's different hearing rooms within the tribunal, but there'll be several cases listed for each of those hearing rooms. At some tribunals, for example, Manchester was starting to list hearings at both 10 a.m. and 2 p.m, but most places, everyone is told 10 a.m, and you need to arrive long before this in case there's delays with security, for example. The judge will decide on the day which order they'll hear the cases. So your hearing might be at 10 a.m, although in reality they start a bit later, maybe 10:15, sometimes even 10:30. Or if you're not the first case, you'll be whenever that first one or second one finishes. When you arrive at the tribunal, you need to go through security. That means going through a metal detector gate, and if you have a bag, it will be searched. Once you go through security, you need to let the reception know, or a clerk if there's a clerk there, and the clerk is somebody who works for the tribunal and they're responsible for getting people into the right hearing room at the right time. There's often also lists of the cases and which hearing rooms they're in on display. But if you tell reception or tell a clerk, they will tell you which hearing room your case is going to be heard at, and there's usually an area of seating for each hearing room. If you've got a lawyer representing you, they should be able to have a quick chat with you before the hearing starts. Now, this lawyer won't be usually the same lawyer that has been preparing your appeal, who's been handling your case before that. Normally, the person who's preparing your case, so a solicitor or maybe a caseworker, will instruct another kind of lawyer to represent you in court. That kind of lawyer is usually a barrister. They're also called counsel. When you're in the tribunal, when you're in the hearing room, they're almost always referred to as counsel. They'll also perhaps be referred to as your legal representative. So you probably haven't met them before, which can be a bit disconcerting, but you should have a chance for a discussion with them beforehand. Sometimes this will be in a private consultation room. Sometimes at hearing rooms that are really busy, like Taylor House in London, it might just be happening in the waiting area. So as we've said, the judge will decide which case will go first. So if you're the first case, you'll be taken by the clerk into the hearing room. The judge won't be in the room at that point. Or if you're not the first case, you'll sit and wait in the waiting area until that first case or the next case is finished. This means you might be at the tribunal all day, so you should take some food with you. It's really unusual for there to be somewhere within the tribunal to buy food, and if you need to go outside, that could cause lots of problems, because if you're suddenly called for your hearing and you're not there, they might cancel the hearing altogether. So you take food with you. There's usually water available in the kind of water chiller machines, and vending machines for tea and coffee. So take some money with you as well. If you've got children, you need to think about whether someone can look after them so they don't have to come to the tribunal with you. It's a really long day for them to hang around, and some judges won't allow them into the hearing room, and you probably wouldn't want them to be in the hearing room in most cases. If there's no one that can look after them outside of the tribunal, so at home or in your community, and you are taking them, there's usually some books and basic toys available, the kind of thing you get in a GP surgery, doctor's surgery. But you know your children, take the things that will distract them or keep them happy, and also obviously make sure you're taking food and snacks for them as well, and if possible someone to look after the children in the waiting area while you're in the hearing room. So let's have a look at the appeal hearing room and who's in there. In this image, actually this is quite a full hearing room. This is probably the most people you could have in a hearing room, the most different kinds of people. As we've said, if you're the first case to be heard, the judge won't be in the hearing room when you go in, and you and everyone else will need to stand up when the judge comes in. If you're the second hearing and the judge is already in the hearing room before you, you just go in and sit down. So you've got the judge sitting at the bench here. They'll come in through their separate door at the back there. They take notes of the proceedings, so they'll either have a laptop in front of them or paper and pen, and they'll spend a lot of time typing or looking down at their notes. You might notice in your hearing, or if you go and watch other people's, that actually people don't look at you very much. They definitely don't make eye contact with you very much, which is quite a strange experience, and it's quite good to know that in advance. If you've got a lawyer, your legal representative, the barrister or counsel we've talked about, they're usually sitting to the side of you. On the other side could be the Home Office presenting officer. This is the representative of the Home Office in the hearing. They're often not in attendance, and this isn't anything to do perhaps with your particular case. It just depends on their schedules and their resources and availability. So it's quite common for there not to be a person representing the Home Office. If there isn't someone representing the Home Office, the judge takes on more of a role and will ask you more questions. If you need an interpreter, this is provided by the court, and they're just available within the hearing room. They will sit next to you, and it's simultaneous interpretation, so they will whisper to you or speak quietly to you to explain everything that's being said. At the back of the room is a row of chairs, plastic or the basic kind of chairs, where people can sit, and this could be random members of the public, because hearings are open to the public unless you have asked for them to be closed because of very sensitive issues in the case and the judges agree with you. So in most cases, they're open to the public. So there could be observers, other people sitting in the back. But this also means that you can take people along to sit in there. You don't want to take too many people. You don't want to crowd the courtroom, as this might annoy the judge. But one or two, a handful of friends, supporters sitting in the back could be really helpful to you as a friendly face, to give you kind of a boost to your spirit as you go through what is going to be quite a nerve-wracking experience. There might be no one sitting there at all in your hearing at the back in the public seating. If you have a witness in your case, so someone who has submitted a statement in support of your case and your evidence and is appearing at the hearing, they will usually sit outside the hearing room in the waiting area, and when their time in the proceedings comes, they'll be asked to come into the hearing room and will answer questions. After they've given their evidence and answer questions, they might leave, they might go out of the hearing room. Sometimes they ask if they can stay and sit at the back as well. The only other people that might be in the hearing room is the clerk. So the clerk is the employee of the tribunal, and they are usually responsible for just one hearing room, and they are making sure that the right people are there at the right time. They sometimes come in and sit for a bit in the public seating at the back. They don't normally stay for the whole of the hearing. When the hearing's actually started, the judge makes some preliminary statements, and if you've got an interpreter, they should be checking that the interpreter speaks to you and you speak to them, so that they can check that you understand each other. If you have a legal representative, they will speak first. If you don't have a legal representative, this will be you doing the speaking. They will usually ask you to confirm your name and address and maybe adopt your witness statement and draw out a few key points. And they won't speak for very long at this point, and they generally don't ask you to speak very long at this point, unless there's something quite complicated that needs explaining. You'll notice in appeal hearings it can almost seem quite rushed and quite routine and bureaucratic. It can be quite a strange experience. It's unusual for you to be able to speak at length, freely, in a form that you would find most beneficial. And again, this is why it's so useful to go and watch appeal hearings, so that you don't have in your head an idea of you being able to make perhaps a long speech about why you need your case to be granted, and actually you're often only allowed to speak in small sections, maybe very specific answers to questions. I've seen judges say that you need to answer this question with a yes or a no. It can be quite a constricted space in which to speak, and I think it's useful to be prepared for that in advance and think about how to get what you need to say across as clearly as possible, as succinctly as possible, and also to really practice answering questions, because in that quite tense, nerve-wracking environment, it can be quite difficult to remember to listen to the question and answer specifically what they want you to answer and get your information across clearly in a way that shows that you are telling the truth. If you don't answer the question, if you misunderstand or you're speaking about other things, this could annoy the judge. They could ask you to hurry up. I don't think there's many circumstances in which you're asked to perform in this particular way, which is why preparing for it is so important. Even people who are great public speakers, confident campaigners, really, really know their story inside out, can get thrown by this quite hostile at times, but also just quite formulaic approach of the appeal hearing. So after your legal representative has spoken, or you if you haven't got a legal representative, then the Home Office, if they've sent a representative, they're called a HOPO, a Home Office Presenting Officer, they'll then cross-examine you. This means they'll ask you questions, often difficult questions about your evidence. This might be related to what the Home Office have written in their refusal letter. So if they think there's discrepancies between what you've said, for example, in an asylum case, between your screening interview and your substantive interview, and it hasn't been addressed in your witness statement perhaps, this is very likely to be the subject of the questions the Home Office ask you. In asylum cases, they're very likely, in other cases as well actually, to be trying to pick apart your credibility. The position of the Home Office in these cases is that you're not telling the truth. So they're trying to pick apart your story, pick apart what's happened to you, pick apart your identity, maybe your relationship to other people. They'll try and undermine that by asking questions that they think shows you're not telling the truth, what you say could happen or has happened couldn't happen. They might do this in a very neutral way. They might do this in quite an aggressive and rude way. So again, it's really important to, like with the asylum substantive interview, be prepared for that, maybe practice with someone not being very nice, a friend pretending to be the Home Office, so you get used to responding calmly and clearly to questions or statements that are put in that way. And the emotion of being told or being implied that you're not telling the truth, which is not a nice thing to experience, sometimes that can throw you off and you don't remember to give your information clearly. So practicing in advance can be really useful for that as well. This cross-examination from the Home Office could take maybe 30 minutes, maybe even longer, and the judge might also ask questions here if something isn't clear. As we've said, if the Home Office don't send a representative, the judge will usually ask you quite a lot of questions at this point. After this, the Home Office representative will make submissions. These are their legal arguments about why they think the judge should dismiss your appeal. After this, you have the opportunity to speak to your lawyer. This could be really important if the Home Office have brought up things that your lawyer hasn't already planned to speak about. So if it's something that's in your witness statement, it's something you've discussed with your lawyer and you've given them instructions about how to respond, how to explain if there's a mistake or inconsistencies or a misunderstanding, they will be able to deal with that without you speaking to them. But if it's something that's come up that you haven't discussed before, then you probably will need to speak to your lawyer to explain what you want them to say about why this discrepancy, gap, misunderstanding has happened. Your lawyer will then make submissions, which is the legal arguments about why your appeal should be allowed. And if you haven't got a lawyer, this will be you making these arguments. If it is you doing it, it's really important. In fact, anyway, it's useful to maybe make notes of what the Home Office and the judge has said so far to make sure that you respond to what has been said, as well as things you've pre-prepared that you want to say. The judge might ask questions of your lawyer at this point. If you've got a lawyer, they don't normally ask you questions again. They'll normally be asking the lawyer to explain the legal points they're making. And then that's pretty much it. The judge will say some closing words and they'll generally let you know how long you have to wait for their decision, which will be in writing. In some cases, they will make a decision on the spot. This is quite unusual though, and normally they'll say that they'll be writing to you within 2 or 3 weeks. Once you've got your decision, what then? Well, if the judge has agreed with you, maybe your lawyer, that the Home Office were wrong and that you should be granted protection, immigration status, they allow your appeal. And the Home Office can also appeal that decision. If they don't agree, if they think actually the judge should have dismissed your appeal, they can appeal the judge's decision. And that's meant to be within 14 days of the decision from the judge. They do this quite frequently, but it's important to note that they lose the appeal of the appeal about 75% of the time. If the Home Office don't appeal, or they appeal and lose, then the case goes back to the Home Office and they should issue you with the status that you've been applying for. Now there can be delays with this, they can really drag their feet, so you might need to chase this up, get your lawyer to chase it up. If your lawyer is no longer representing you, you could ask your MP to follow up on this. If the judge dismisses your appeal, if they've said no, they say they agree with the Home Office, there are still legal options for you. You can appeal at the next level, which is the Upper Tribunal. You need permission to do this, and it gets quite complicated because to get permission, you first of all ask the first tier tribunal, the court that's actually just refused you, for permission to appeal to the Upper Tribunal. If they refuse you, you can then ask the Upper Tribunal for permission. It's important to note that this should be based on there being an error of law in what the judge decided. You can't just say that the facts are as you've said they are, the Home Office and the judge have just got it wrong, they should believe you. You need to demonstrate there's been an error in the way the decision has been made. Even if you don't succeed with this, there are some other options. There's a possibility of a judicial review, but this is quite difficult to do and almost impossible without a lawyer. Also, if some time passes, there may be new evidence that shows that you are telling the truth, that you do need the status you've asked for, and then you might want to gather this evidence and submit it to the Home Office to be considered as a fresh claim. You can have a look in the toolkit for more information about all of this.